turn to Chris and talk about the actual bringing of a civil action, which I believe we started about page 13 of the outline.
Yep, so you submit your notice to the LWDA, you've waited the 65 days, the LWDA doesn't respond because they never do, to be honest, and so you're ready to file your lawsuit. And what do you need to put in your lawsuit to validly state a Paga claim? In our opinion, a valid Paga lawsuit should have 4 elements. The first, the plaintiff must plead exhaustion. Second, the plaintiff must identify the aggrieved employees. Third, the plaintiff must plead facts sufficient to support the underlying labor code violation. And fourth, which is not necessarily settled law, but the plaintiff must plead facts necessary to proceed on a representative basis. And I'm going to take each of those in turn and provide a little bit more color. So what does it mean to plead exhaustion? You must plead enough facts to notify the court that you did in fact exhaust with the LWDA and that you waited the requisite number of days before filing. So the best practice I've seen from plaintiffs is that they plead the date that they sent a letter to the LWDA and state that the LWDA did not respond. Alternatively, I've seen plaintiffs attach the LWDA letter to the complaint and just simply plead the date on which they sent that letter in, and in both circumstances, they've met the requirement of pleading exhaustion. The second element, the plaintiff must identify the allegedly aggrieved employees. Typically, this starts with the LWDA letter, but it does carry through to the complaint as well. Courts historically have held that a plaintiff cannot simply just try to represent all employees without there being some specificity. Excuse me. Because you need some specificity to put the employer on notice of the scope of the aggrieved employee group that's bringing this Paga claim. But more recently, cases have allowed plaintiffs to plead on behalf of all non-exempt employees. Recently, there was a case, Zayers versus Kowit Infrastructure, and in their Paga letter and their pleading, the plaintiff sought to represent 3,450 employees that were divided into different crews, covered by 10 different unions and different collective bargaining agreements, and the court let that case go forward. I think the best practice is to provide some specificity, and the most effective way to do that is for the plaintiff to plead the job titles or the job duties of the employees he or she seeks to represent. On page 15 of the outline, we discuss cases where the courts have found that plaintiff's identification of the aggrieved employees was deficient. In one of those cases, Jesk versus California Department of Corrections, the plaintiff alleged facts specific to her position and did not indicate which other employees suffered similar violations, so that wasn't insufficient. In Kahn versus Dunn Edwards, in a similar situation, the summary judgment was affirmed for the employer because the plaintiff failed to specify or reference the claims of other employees and didn't make any reference to any other current or former employees. And then finally, in another case, also entitled Jesk versus Maxim Healthcare Services, the definition of the aggrieved employees was predicated on the occurrence of the violation. So, for example, aggrieved employees is everyone that missed a meal period, and the court said that was insufficient to put the employee, the court, and the LWDA on notice of who the aggrieved employees are. Just a practice tip for the plaintiffs, you can't expand the aggrieved employee group broader than what you represented in the LWDA notice. So when you are bringing a claim, just limit it to the LWDA notice. At least one case, Chai versus Reed, found, which is on page 15 of the outline, found that when the plaintiff failed to specify in the complaint who the aggrieved employees were, the court defaulted to the definition of aggrieved employees in the LWDA notice. I don't know if a court would do that if the LWDA notice is not attached, so I would keep that in mind. Finally, to bring a Paga, the third element, you need to plead facts necessary to support the underlying labor code violation. To bring a Paga claim, you yourself have to be an aggrieved employee. And to be an aggrieved employee, you must have suffered a labor code violation that you're alleging in the complaint. So your complaint needs to set forth facts to support the underlying labor code violation. This issue came up in Mendoza versus Nordstrom, which is on page 16 of your outline. There, the Ninth Circuit affirmed dismissal of plaintiff's Paga claim because plaintiff could not establish the underlying violation. In that case, the plaintiff was claiming that defendant did not entitle her to a 1-day rest and 7 days of work, and a look at plaintiff's time records revealed that she wasn't entitled to 1 day of rest and 7 days of work because she didn't work the requisite number of hours to trigger the statute. And so for that reason, the court dismissed this case. One interesting note about Mendoza, and I think that addresses one of the questions that was asked earlier, the Ninth Circuit said that even if the plaintiff were to find another employee who did suffer this violation, that new employee could not simply step into the shoes of now the dismissed plaintiff and continue on with this Paga action. They would in fact need to have filed a new Paga letter and bring a new Paga action. The fourth element, and as I mentioned earlier, this one's unsettled and it hasn't been explored by any court recently that I'm aware of, is that the plaintiff needs to plead facts necessary to proceed on a representative basis. What that means is that the plaintiff is required to plead that her claims are typical or similar to the aggrieved employee she seeks to represent. This issue arose in Bazawa versus City of Montebello. It's an unpublished decision out of the California Court of Appeal. There, the California Court of Appeal affirmed dismissal of plaintiff's Labor Code 1102.5 claim because plaintiff had not explained how the allegations in his complaint concerning his termination provided a factual basis for a violation of Labor Code Section 1102.5 with respect to any other purportedly aggrieved employees. So what do defendants do if one of these elements isn't met? You can move to dismiss or strike, particularly with failure to exhaust or failure to plead exhaustion. That's not a jurisdictional issue, so we recommend you raise it early on in the case and you plead it in your answer. So let's turn now to the timing statute of limitations with respect to bringing a Paga case, which starts on page 17. It's settled law that Paga is controlled by the 1-year statute of limitations for penalty claims set forth in the Code of Civil Procedure, section 340. That statute of limitations period, however, is told for 65 days once the plaintiff submits the LWDA notice to the LWDA. During those 65 days, while the LWDA is reviewing the notice, the plaintiff cannot amend or file the lawsuit, cannot amend an existing lawsuit or file a new lawsuit alleging a Paga claim, and for that reason, everything is told. It's important to note that a deficient LWDA notice, however, does not toll the statute of limitations, and that arose in Brown versus Ralph's Grocery Store, which is on page 19 of the outline.